let me talk about wills. So wills, so the advance directives for medical power of attorney, financial power of attorney, they're good till the minute you die. After that, your wills. People say, what was his last will and testament? Okay? So you will do a will, obviously, while you're still alive. And after you die, this is the most important, this is your last statement. These are your last wishes. Some people, it's important to state what your wishes are, you know, so people can, it minimizes the fights. This is your chance to keep the peace in your family after you pass. Okay, good. And so very quickly, some people do wills, some people don't do wills. Okay, so this is your last wishes. Obviously, you write them when you're still alive, and after you die, people say, do you have a will, do you not have a will? If you have a will, you have these last wishes, people know you've got the clear, the certain trumpet call saying what it is you want, how you want your estate distributed. After you die, it's always an emotional time, but say within 3 months or 6 months, somebody you've designated as your, after you die, it's called your personal representative. It used to be called executor, still is sometimes. Mostly it's called PR, personal representative. They might go down to probate court and they fill out a petition for informal probate, meaning I've got a will, I'm named as the personal representative in this will, and here are the heirs, and these are the heirs. The heirs are your blood relatives. Your devisees are the people you give things. So if I were to give to my siblings and my neighbors, all of them are my devisees. This is more than you need to know. My heirs are my blood relatives. They might be my devisees or they might not be. You know, it's blood. But anyway, they go down and you list all your heirs and devisees so everyone gets notice that something is going related to a loved one. They all get notice that this has been filed, and if nobody contests it, it stays informal, okay? And then the personal representative is given the appointed powers to pay the bills and distribute the estate efficiently. So, first thing a personal representative will do, I'm getting a little ahead, but there was a lot of questions, a lot of comments when we went around about what is probate and do we need it? And probate is a way to get all your bills paid and get it distributed and then to get it closed, and may everybody and everything rest in peace thereafter. Yeah.
If your will on her part says she is the PR for this will, she has the authority to buy, sell, and everything, and divide equally amongst 4 people in a will, why does that have to go to probate? It's cut and dry.
Well, there's sometimes it is cut and dry, and sometimes it's easy, but sometimes say there's property, and there has to be a deed of transfer, and to have the authority of the probate court to basically be part of this process. It shows that it's just it's a trustworthy, it has the imprimatur of trust because it's official, everything's on the record. Also, with probate, there's a certain amount of time when people can come and say, oh, Joe owes me money.
What is that time?
It's anywhere from 4 months to 9 months. It's a nice, from the time of after appointment. There's a whole process. So, say that right before you died, there was a carpenter who never got paid, and he reads a notice in the paper that you died, and he knows how to let the personal representative know he's owed money, and the personal representative says, yep, okay, I'll pay it right off, it's paid. Or the personal representative says, oh, I don't think that's true. I don't think that carpenter did that. And so the personal rep says, I'm disallowing that claim. And then the carpenter could come to court, and instead of, once things get diced, once there's an argument, it goes from informal to formal. So it goes from the registrar's office, where everything can be done informally, to a formal court procedure with judge and notice and hearing, and it's formal. And then the judge will decide, is this a bill that should be paid? But say the carpenter doesn't get around to sending his bill till after the time has elapsed. He's missed his opportunity. And so the PR didn't get the bill, didn't pay the bill, didn't allow it, didn't disallow it, didn't get the bill. Figures that the time has elapsed for the collection of all the bills. She's paid the one she's allowed. Now she's at the next stage, distribute the estate. She distributes the estate. 5 kids or 4 kids get what you had requested, and then the carpenter's bill comes in after, when it's too late. It's too late. What's the beauty of probate? There's a nice time, certain amount of time, where once you get to the closing of the estate, you have dotted all the I's and crossed all the T's and been transparent and open and given everyone notice every step of the way. After that, people just have to accept the result. So there's finality. That's one benefit. There's still, I hear stories about people who don't want to be bothered with that. They don't have that much. They pay their bills. They don't have that worry. For me, I prefer knowing that I did everything fairly quickly and efficiently after, and everyone else had to follow the time frame, and then there was a point at which there was finality and closure. And there's a lot to be said, I think, for in terms of grieving and in terms of finality. It's like, it's not as serious as, say, a funeral and a burial, but when those estates are closed, I consider that an important piece in the moving forward, because you've honored that person's, the decedent's wishes, and then you've closed the estate, you've paid their bills, you've distributed their assets, you've closed it all nice, and it's official and done, and you get to move on. And everyone else after that, you've dotted the I's, crossed the T's in an official manner, and you get to move on. So that's what I see as the benefit.
So if she's the person making these decisions, and the court has to go through to give her permission.
Often it's informal.
Well, even if it is she still going to wait 9 months before doing anything with the property, or?
It's 9 months is nothing. The statute used to talk about 20 years for. And you know what, too? Not many family members or people nominated as PR walk into the registrar's office at probate within a month or two, that there's a certain amount of time, which the last thing they're thinking of is starting the informal legal process, that there's other things going on emotionally. So the 9 months is pretty quick for when someone dies and they're much loved.
Wait then. You shouldn't do anything.
My general sense is if they take 3 to 6 months to just do the grieving, that there's no real hurry, but as soon as they start taking the steps, that will be another stage that they have gotten through in their grieving. And it's a very honorable thing to take someone's estate, figure out what's in it, pay the bills, distribute it, and close it. It's a lot like just, in my opinion, it's an honorable process similar to, but some people feel they have that much money. They don't worry about deeds of transfer. They don't worry about, they'll figure out a way. Some people have everything in joint ownership, so if you and I had a joint bank account and I die, you're the survivor by operation of law. And that's not a part of the decedent's estate. It's already outside of it. Life insurance policy, beneficiary, many of those non-probate transfers are taken care of outside of any probate process. But there could be one thing that you didn't know, like you won the lottery the day before you died, or Huh? Pardon me?
When if you don't play? So anything that's held in joint custody
Right.
is not part of someone's estate?
It generally, no. I don't want to get into legal advice and legal technicalities, but generally, if you and I had, say, joint real estate, and I die, you're the sole surviving owner, and it's by operation of law. It's already in your name before you have to go through any probate process and put it in your name.
Right, because I thought if you have to wait 9 months to go into probate till you can.
Oh, no, you don't have to wait 9 months. The question was.
No, I mean, if it's 9 months before it's done, you wouldn't even have any money to pay bills, right?
Okay, the question is that if if there's this limbo period around paying bills, if you don't have authority to pay bills anyway, it's nice to have some authority to pay bills. Like when you are informally appointed personal representative, then you can pay bills. Okay. If you are not appointed, how does anyone pay bills? Right. Okay, that's another benefit. Just to get the bills paid. It's cleanup, important cleanup, and it's honoring that person, saying, you left this, you're deceased, I loved you, I love you, and let me inventory your estate to figure what's in it. Let me put a notice out that anybody who's owed money, let me know. Let me determine if that's a legitimate bill. Let me pay that bill if it is. If it's not, maybe we need to go formal. And let's give notice to everybody. And if anyone wants to contest the will, saying, oh, that was a will that was under duress. Next, there's a will contest. There's a process to get it before a judge. That will be a formal process. So hopefully it's informal, where things are nice and neat and clean and nobody's mad and everybody's happy and everyone's respecting. That's not always the case. If ever an issue comes up, there's a way to get the issue resolved. And the policy behind the administration of decedent's estate, the main public policy behind this is for the court to move efficiently and for the PR, personal rep, to move expeditiously, to clean up this person's estate so the economy can move on, people have inherited their money, get their money. Now let's say there's no will. What do? Well, you come to probate, somebody wanders into registrar's office and it's called an intestate, meaning no one has done their last will and testament. And then how does everything get distributed? Well, first bills get paid, and then how does everything get distributed? It's common sense. We look at, okay, who are the family here? Are there any children? Are there any adults? Are there any siblings? And what does the wife or the husband get? If they want, they can ask to get their elective share. They can elect to get, I think it's 1/3 the estate, and basically, what's an elective share? It's when the surviving spouse elects to take a large chunk right off the top, essentially, okay? Why would that be? It dates back to the times where, pardon me, but it tended to be the men were the breadwinners and they left everything to the new bride. And the poor first bride was left destitute and on the public dole. And the policymakers said, enough, we're going to give, actually, it wouldn't be the new bride, it would be the girlfriend. And the bride would have been left with nothing and on the public dole. And so we developed over time an elective share where rather than the wealthy breadwinner leaving everything to the girlfriend as opposed to the wife, let's give the wife a chance to live on the husband's assets.
But that's with no will.
No. Go on. I'm going to be looking up elective share.
Okay. Well, personal representative in this, it says in a sequence, first representative, if that person's unable to serve, then the second. So is it correct then that you don't do co-personal representatives like we did we were able to do joint powers of attorney, but personal representatives are a singular person?
I think the law is silent on that, and I think if you want co-personal representatives, you can have. You get to decide what it is you want. I think they probably have to act together, that one person can't act, they can't act separately. I've never really had that question. Okay, ask your question again.
Okay. If I made a will,
Yes,
and I'm leaving everything to my husband.
yes.
Can I, or if we both die in an accident, and we say if one or both of us were gone at the same time, to name our daughter, she would be getting everything we have. And can we also name her as a person?
Yes, yes, absolutely. You get, yes.
You can name the person?
Yes, 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 yes. And the process will be so that she's protected, because she goes down to probate, she gets informally appointed personal rep, she pulls together the inventory, she puts notice out about the bills. If anyone wants to come to court and look at that will, it's right there. They left everything to her. It's transparent. And then she pays the bills, and then she, if she, distributes all to her per the will. People can say, oh, greedy. Well, it's not greedy, it's what their wishes were. So she's protected by the documentation that is in a court of public record.
And do you have is there some way to do your will, like normally speaking, one person dies, leaves it to the spouse?
Yes.
And is there some way to designate if some unforeseen thing happens that both spouses go at the same time?
Right. Let's go through the will on that note, but first I want to answer a question. Your question earlier too was, is the elective share related to when you don't have a will? And I thought yes, and I thought, oh, I'm tired, maybe I'm wrong. And I'm now looking at the statute, and it goes on. Let me read what the statute said. The intestate, so it seems to be, I was right, it's intestate share of the surviving spouse, or is, if there's no surviving issue or parent, meaning no children, no adult, the entire intestate share, the entire amount can go to the spouse. If there's no surviving issue, but the decedent is survived by a parent or parents, the first $50,000 plus 1/2 the balance goes to the spouse. Okay, large chunk. And then if there are surviving issue, the first $50,000 plus 1/2, but no, and then the opposite, if there's kids, but no one up here, meaning parents, the first $50,000 plus 1/2 of the estate goes to the spouse. And if there are surviving issue, anyway, that's the gist. Now I have to get to elective share. I thought that's what I was reading. I'm going to keep on looking as we talk, because I want to make sure I get that right. Elective share. Okay, you ready, everybody? That's more my issue right now than anyone's, because I want to be right. If a married person domiciled in the state dies, the surviving spouse has a right of election to take an elective share of 1/3. It's not really restricted to intestate. It's intestate or testate. The surviving spouse always gets the opportunity to choose 1/3 of the estate.
Just 1/3. That's all you only get 1/3. And what happens to the other 2/3 of your estate?
Goes to the kid.
The question is, and I'm going to step right in on this one, the comment among the gallery is that if the spouse only gets 1/3, who gets the rest? The peanut gallery thinks the lawyers get it. The lawyer in the room is saying, wait 1 minute. We wish. Actually, there's also things called augmented estate, and figuring out and that's more legalese than I want to get into, but also there's the homestead, meaning that there's also a chunk of change, pardon the Gaelic, that goes to for the homestead, for the surviving spouse. And also there's something else, I think another $7,000 called something, but those numbers are going up all the time. In fact, I'm working with a group of people, and we're raising those amounts, because the $10,000 in homestead and the $7,000 in whatever else that's called is really nominal, given how expensive life is now.